advantages.
All right, am I on? Yes, I am. Hello, everyone. How are you? Does my accent confuse you? Yes, I am Indian. I've been asked that about 25 times today. I also grew up in New York City. My name is Aarti Shahani, and I'm a reporter with a company in the US called National Public Radio. Think of it as BBC for America. And I am very happy to be here in Andhra Pradesh. It's actually my second time here this year. A few months ago, it was for a wedding of a best friend. It's a beautiful state. And we're going to talk this afternoon basically about data and data ownership. And I'm joined with 4 experts, very different kinds of experts. I'll do a quick introduction of each person, then present the questions that I have, and we can open it up for Q&A as well. And when it comes time for Q&A, I was instructed to throw this. And so if I hit someone by accident, we also have a medical expert on staff. All right. So, you like it? Yeah, exactly. We can take it out first. So, on the panel with me, I'll just start with people's bios. I almost said biodata. Shailesh Kumar is Chief Data Scientist at Reliance Jio. And as he was saying, you could just call him the ex-Google guy, is another way to think about him. And so a background as a technologist to talk with us here about data ownership issues. Jeffrey Morrison is a lawyer who is trained in the United States, currently lives in the United Kingdom, and has practiced intellectual property, international white-collar litigation, a range of expert area practice. Dan Sheffet, to my left, is a lawyer at the Paris Court of Appeal in France, and he's best known for suing Google and winning a case called The Right to Be Forgotten, which I'm sure you'll talk about. And Ananda Durapaya, did I just say it right? Oh, help me. Duryappa. Ananta Duryappa is director of UNESCO MG IEP, and you're an economist, correct? Yeah, so we have an economist, a technologist, and 2 lawyers and a journalist here to talk with you about data ownership. And the first thing that I wanted to start with is something that struck me in walking the halls and looking at the different booths that are here, and talking to the particularly the different young people who are here and who are very excited about the things that they're building or thinking about building, is that there is in this conference and in this room people who are really excited about how technology can, for example, really close the education gap, which is enormous in India, not just in India, but around the world. And one thing I thought we could do is, beginning with Shailesh, is talk a little bit. If the purpose of this panel is to, alongside optimism of what technology can do, the purpose of this panel is to kind of help you be also a bit skeptical, to collectively foster not just joy and excitement, but also healthy skepticism about what can go wrong. Maybe, Shailesh, you can begin by talking with us about when people say that data is the new oil or the new gold, what does that mean?
All right, so, if you think about the IT revolution that happened, let's say 30 years ago, and the AI revolution that is happening now, right? And there's a big paradigm shift between what we thought technology was when we talked about IT and what we think technology is when we talked about AI. So, just to give you a very quick difference, IT is about installing a software, and AI is about improving it over time after usage, right? So all intelligent systems are not installed, they improve. So if you think about, for example, animals with lower intelligence, they are born with programmed instincts, right? But intelligent animals, use data to improve their behavior and survival rate in the world. And that's the key difference between instinct and intelligence, right? Between IT and AI. And if you think about how Google becomes better, how Uber becomes better, how Amazon becomes better, how Netflix becomes better, it's not because they have just installed some software or you're using it. It's because all of us are collectively giving them data constantly. And that data is what makes them better for each one of us, right? Now, this is one direction, right? A purely technologist view of it. And this, we're going to discuss, the other side of it, which is how much data, what are the boundaries of it and all that. But without the ability to collect and analyze and understand the patterns in the data, we cannot make our systems intelligent. So your auto suggestion in Google will not be better if they were not collecting the queries that we are doing, right? All kinds of things like that, right? So the Olas and Ubers won't know where to put the cars at the right time if they were not collecting that data that says how many people need a cab in this part or this part in the morning or evening. So without data, we won't be able to improve the systems. And that's the whole point of the transition between IT and AI. And therefore, even in education and other areas, if you see why, let's say, education in India and healthcare and agriculture have not made that much progress versus other areas like, e-commerce and search and others have, the only difference is we don't have a data platform for collecting data on education or data on healthcare or data on agriculture. So those systems are still driven in the old way, and the other systems that have seen the usage of data and all that have improved constantly over time. And so that's the kind of transition that we need to think about, but with all the guardrails in place. Thank you.
So with that, if we're thinking about the data itself as a resource, and a huge question we have as you think about the ways that technology can be used in schools to automate certain processes, to close certain gaps, one question I have for each panelist is, can you help us to think about the nightmare scenarios? What are the things that could go horribly wrong that maybe we don't want to think about right now, but it's worth thinking about? What could go very wrong as we let artificial intelligence into the classroom? Who would like to dream up a nightmare first?
Hello, my name is Jeffrey Morrison, and as stated, I'm a U.S. lawyer living in England. And the difficulty I have with the question is to only think up one nightmare scenario. So I'll start by sharing a thought with you that each of you, kind enough to come to the panel today, each of you has data, personal data, about yourselves, about your job, about your education, about your aspirations, about your religious beliefs, about your taste in food, about allergies, about medical conditions, about your emotions, about problems in life that you've overcome, et cetera, et cetera, et cetera. And while that data may seem to you to be very personal, which it is, that data has value to third persons, some of whom can use it properly to help you select the right meal or the right restaurant or the best travel package for your holiday. But unfortunately, as a lawyer, I know that there's another side to human nature where there are people or groups that will attempt to abuse your privacy and your data. So first of all, the data belongs to you. And there's more data that belongs to you than you probably have imagined. Number two, the data that you have is much more valuable to you and the people you care about than the people that want to take it from you will ever pay for it. In other words, there's nothing for free. So your data is more valuable than the technology or gifts or cookies or other benefits that you think you will get. And I hope that I'm not being politically incorrect by saying the following. One of the most serious nightmare examples would happen if a given country or the people in that country felt, well, we are a developing country, we are so grateful to have this opportunity to jump into the fourth, fifth, sixth industrial revolution, and if doing so means consenting to what we're asked to consent to, that's a price worth paying. It is not. So the first nightmare scenario would be to deprive yourselves and your loved ones of rights that are yours and that there's no reason for you to give up. I repeat, the data that you have is more valuable to the people that want to get it from you than anything they will ever give you. So it's a question of negotiating power. Number two, even more important, the data that you have is only the beginning of a data journey, and that's why they're interested in you. They want to benefit from the data that you will create under their guidance, but under their surveillance of you, sometimes with you not knowing that you're under surveillance or knowing the purpose of surveillance, or with you thinking that you have not consented to it, whereas in fact they have a very, very different purpose. So, example, I'm not going to name any particular companies because that would be improper, it would be biased, and I'm not biased. Business has an important role to play, government has an important role to play, people have an important role to play, but this conference is called Education for Humanity. So for example, nightmare scenario. I'll just give you three simple examples and let you choose which you think of the three might cause a nightmare for you. And my answer is almost over. Example number one, a legal example. What would you think about a company that had a legal monopoly, in this case called a patent, or patent as it's sometimes pronounced in England, where I live? What would you think about a patent or legal monopoly that allowed a company or group or government or foreign country, every time you or your child or your teacher goes online, it tracks your eye activity to see which part of the screen you're looking at and for how long and which images and which words you are looking at. It can do that. Technology can do that and store it and use that to derive predictions about you and your future behavior. That's one. Another one, how would you think about a company that had a legal monopoly or patent every time you go on to a computer to analyze your words that you read or words you use in your messages, or the time that you spend looking at certain websites or certain content, and using that to develop a profile about you to sell you something or to influence you not to do something that you would want to do, or to think differently about something than you would have otherwise. Those themselves don't sound like nightmares, but think of how they could be used against you, and they already have. I live in Cambridge, England, which happens to be associated with an event that we're fortunate to have had uncovered called Cambridge Analytica, whereby it is alleged that Cambridge Analytica, now a bankrupt company, improperly gained personal data about hundreds of thousands of people, mainly in the UK, by making them think that they were filling out a survey. So they thought that they were getting something for free, and all of us have egos, and we like to be asked our opinions, but the purpose of the survey was quite different than doing something about them. It had to do with abusing their information for another purpose. This case has not been adjudicated, so I'm not accusing anybody of having done anything wrong, but it is alleged that part of the abuse of that information was to influence elections in the United States in England and in certain states within India and perhaps also the country of Kenya. Well, maybe that happened, maybe it didn't, but something that can imperil your democracy or make you have disbelief in democracy is a nightmare. So that is my brief answer. And thank goodness that Cambridge Analytica got caught, because now we know to not be unobservant the next time. So the worst nightmare would be not to pay attention to the warnings we have already had.
Thank you. Dan, would you like to add anything to that? You're on.
I'm on the speaker. Artie, we don't have to imagine the nightmare. I mean, why do you think that data protection and privacy is so strong in Europe? Because in the last century, we had two, not one, but twice we had totalitarian regimes in Europe. We had the Nazi Party and we had communism. And both of them, and this is not imagination, this is history, both of them used surveillance as a way of maintaining power. And they did that for 70 years. Now, the first time I met with the then Minister of Justice in Germany, Sabine Leuthauser-Schnarrenberger, who's known to be privacy champion #1 in that country and maybe also in Europe. She told me that she was actually born in what was East Germany when it was under the Soviet Union. And when she became Minister of Justice, she wanted to have access to the files that the Stasi, the secret police, had on her and her family. And she got it because the Stasi files were opened. And she was in a complete state of shock. She learned more about herself and her family than anybody would ever have told her. Now just imagine that was possible with the technology that we had in the beginning of the 20th century and at the other half of the 20th century. That technology is Stone Age compared to what we have now. So Artie, we don't have to imagine nightmares. We've lived them. And we don't want to see that happening again. The data that is today collected is collected very often by corporations. We don't want to mention names, I totally agree, except that I will also second what you said in terms of Cambridge Analytica. And that's just one example of things going very, very wrong. Even if these corporations may try to keep that data safe, we would be completely naive if we overlook the fact that every day, every single day, there are thousands of computer hacks taking place every day in this country. While I've been speaking, there's probably been 100, all right? Some of them we learn about, some of them we don't learn about, some of them are successful, some of them are not. We're just waiting for the big computer hack. We had it in Equifax in the US, we had it with Yahoo, and what's gonna happen when that mega hack takes place and all that information falls into the wrong hands? So Artie, we've lived it already and we don't want to have that again.
You know, I would though add that as I sort of listen to you both, a layer of it that becomes new when we talk about what we can do in the classroom and education is, you know, young people are developing, and a lot changes over the course of from your first grade to when you finish your 11th standard, when you finish high school. When I think about the possibility of companies that are saying they're giving you something for free, also collecting data on student behavior, what kids seem to learn faster than others, what kids seem to gravitate towards more emotional language than others. There are so many things that you can actually identify about young minds and then make very strong judgments about what door they're allowed to pass through as they enter a next phase in life, you know? And I think that the kind of social scoring that we're seeing now in China, for example, where citizens get scores and you can be denied access to credit line, to a loan, to certain kinds of life experiences, that's the kind of thing that I think Europe and the US has not yet seen in these sort of very visceral, obvious examples, but are, you know, really concerning.
I'll just comment on that. In terms of being denied access on the basis of data, the General Data Protection Regulation that I think you all know about, at least you heard about it, which is a European invention based on the historic experience that we lived through, actually in Article 22 prohibits predictions based on data which will automatically disallow you access to insurance, to education, and so on and so forth. It's very, very important what you say, and the GDPR actually has taken that into consideration.
Ananda, a question that I had for you that I thought maybe you could help us to think about is, so I will name companies. One company that comes to mind for me, for example, is Google. Google and I'm just stating a fact here, Google very regularly says that it's okay that we mine the data that we do because users consented. In 2014, Google tried to make that argument when Google was caught taking the email addresses of students and basically tracking students from their educational apps into Google search in a way that was in violation of a lot of people's expectations. Google said, hey, people signed on. They said they've given the consent. They got caught doing it, and that's why they stopped. And so I'm wondering, do you think that the standard line of some of the large technology companies, which is, hey, user consent means we own the data and we have carte blanche to a certain extent with the ways that we might be able to mine in the future. Do you think that that is an adequate approach?
What was the name of the company?
Well, it's an interesting question, and I'm a little bit surprised that there hasn't been much discussion within the community on property rights. When there's a lot of literature on managing of common resources within the natural resource management thread. But for some reason, I haven't come across that much literature on this. And the way I see, and I'll get to the question, is to sort of classify information. I would call that the content which is put on the net, I call it a first order information. And whoever the company is owns that. Say if it's a content, a mathematics course or stuff. But what's more important, and there's not much discussion, so most of the patent laws are all looking at that level, first order information. But the second order information is the behavioral aspects that these companies are really going after. Because that's the goal, not the first one, but the second order. And so it's an interesting dichotomy that arises where you own the first order content, but you're not allowed to manage the second order information. And that management falls into, and I have no answers. If say a government, well, we know what that happens as well. And this is an area that being kind of exploring on where maybe the United Nations has a role to play, because what was established was post World War II. Things have changed. We haven't changed accordingly to the agenda. We are still in the development phase, putting roads and bridges and schools. But we haven't really understood the nuances and the advancements that have been made in this field. And information flows across borders. So it needs an organization which is able to transcend borders as we see today. So that's an issue. I think that's a topic that we need a discussion on. We're still talking about that first order information, but I think the really important one is the second order. But that right now, it is by default the owner of the first order information. And I think we need to make that distinction.
And so if one builds on the other, just coming back to the kind of question I have, which is, what does meaningful consent look like from a user? Is it the student whose parent says, yes, yes, we'll use this in the school that's like, hey, just check this box? Is that meaningful consent?
Yeah, and I think this is a ploy by all these companies. By the time you read, so when you get onto into any new application that you want to download or something, it's about 6 pages that you have to scroll down before. And none of us is, so we just go, and then I say, I agree because I have no time. And even now with the GDPR that you pass, so what do we get? We get the 6 pages now on a more regular basis, but we tick the box.
Actually, as a footnote, I refused to install the conference app because I didn't, yeah, as did Dan, because I didn't want to give any of the information away from my phone. And so as a matter of habit now, the more I report on privacy issues, the less willing I am to install apps.
So this is where it was interesting when you told me that, because we kind of trying to push everybody to download the app. And we wanted to get, so as an organization that organized this conference, we were trying to, and I'll be straight out, in trying to get that information so that we could sort of use that in terms of looking at where the interests are, from which parts of the world have different interests, how to cater that, how to redesign next year's conference.
How to better target.
And we're looking, and so we're targeting as well. So the best thing I think we can do is get everybody into a mindfulness, empathy, compassion training program so that we are all like-minded in looking at not trying to exploit the next person and trying to help the next person.
If I may just add to this, it's funny that you and I, we had the same reflex, so to speak. Meaningful consent, let me just get back to that. It's true that after the GDPR, what we see in Europe, and you probably also see it here, because the GDPR is being exported, is that you have to accept cookies, right, in order to enter a website. Now, the European Commission knows that that is what has actually happened, and that people simply tick the box, they accept it, and so there's been a lot of sound and fury signifying nothing kind of thing, right? It's just irritating. But the explanation is that the so-called e-privacy directive, which was supposed to be passed and enter into effect the same day as the GDPR, which was the 25th of May this year, for political reasons was postponed. What will happen probably early next year is that the e-privacy directive will enter into force, and that will actually allow the big difference on consent, which means that today the legal problem is if you refuse to give consent to enter a website, right? I want access to NPR, right, in Europe, and I don't want to accept the cookies. Can NPR, under current laws in Europe, and maybe also here, refuse access, right? If I don't accept their cookies, can they say, okay, you can't see our website? That is an undecided legal question in Europe under the GDPR, but the privacy directive will be very clear on this, saying that you can actually gain access without accepting the cookies, which will mean that in Europe, this kind of ticking the box, which is I agree, I don't agree, will disappear. All you have to do is to opt in and out for the cookies, and in any case, you can gain the access. That is meaningful consent. That allows you to get the benefits without giving anything up.
Being forced to, right. Shailesh,
Yeah. So on the consent, right? So I think the savviness of the digital companies is very high on what they can and possibly do, with the data, and the understanding of the user on what you're asking for consent for is very innocent at this stage, right? So, for example, there are a lot of apps right now who say that I need access to your SMS data because I can use that to build a credit score for you based on your SMSs from banks. And do I have consent to read your SMS, right? Now, I am thinking that, hey, they're going to use it only for that purpose and only use those SMSs, but it's a very private financial data that I'm giving them access to. Not only that, I'm also giving them access to all my SMSs. Now just imagine Now, when I'm a user, I need a loan and a digital way, and I'm in a village and I'm ready to do whatever it takes to get the loan. I'm not worried about the misuses of it, right? So the education of people in the digital era on what can go wrong when you give consent, and the specificity of the consent, which is don't just give me SMS access, ask me more specifically how you will use it, which SMSs will you not touch and which you will touch, right? This degree of specificity is always important. Just saying yes and no to cookies, even if I say yes, I have a common sense understanding of what I think these companies will use it for, because they're not saying that. But still, there are people out there who are willing to, sell cookies and hack into systems and do bad things with them. And the specificity of the consent is actually an important issue, and that becomes a 200-page document than already a 50-page document.
I think it's interesting also what you were talking about in this context is you work with so many different sectors in this country. You were giving, for example, earlier the example of farmers who you can ask them whether or not they're okay with you tracking their crops, and they're interested in the immediate issue of, will this tool help me to do my job? And so just describe that dynamic. It's a power dynamic.
Yeah, it's a power dynamic. And at the time that you're asking for consent, at the time when you build the Facebook for the first time, you were not thinking about what you will do 10 years later. But you have started collecting the data 10 years earlier itself. And people change, greed comes in, regulations are loose. For whatever reason, because the data is sitting somewhere and I can use it, and the so-called regulations allow it at this point, and nobody is watching, let me try this, right? And at that point, I'm not thinking whether the user would think that this is consensuous or not. I'm just thinking, how can I gain more market share, improve my services, and things like that, right? Let me give you an education example from a data and consent point of view. So imagine your kid is being taught by a tutor, right? So there's a home tutor who comes to your home and teaches your kid. Now this tutor has learned enough about your kid's strengths and weaknesses and other things, right? Now this same tutor is teaching many other kids. He's also learning, about the nuances of education and how to teach by teaching many other kids. That's why we like, experienced teachers, because they have a lot of data, right? And they use all of that data to actually teach each kid differently and better. So that is consent. Everybody knows this is common understanding. But when the same tutor goes to an HR department of a company and says, I know that kid and he was not good in this and that and you should not hire him for that reason, that's when, so is it the problem of technology, or is it the problem of how we use technology, right? So sometimes the more important question is, should I do it versus can I do it? And that transition has to happen. And therefore ethics in AI is a very important area, not just regulation, but ethics. And engineers have to be taught what is the line, how do you identify the blurriness, and if it was happening to you and your kid, would you allow that or not? If that is the question and you're saying yes to it, then you can do it, right? And the same thing you did with the app. And somehow we need to bring ethics in AI as a very important area. Otherwise, we'll do a lot of mistakes before we learn from them.
I wanted to ask Jeffrey, Dan was beginning to talk a bit about Europe and the privacy regulations passing there and evolving there. Can you give a sense of what the evolution has been in the US? Because it's been very dynamic.
Yes, I'll gladly do that, and I'll try to link it into the comments that have been made in the past few minutes regarding, for example, the power dynamics and the issues surrounding consent, because consent to me is a key element in any marketplace decision. Capitalism does work, and I have made the statement that I believe that your data is more valuable than you having to give it up in return for something, frankly, as demeaning as being told you're being given a cookie. So what type of consent you give is very important, and if it's 6 pages or more, you should know what it says and know that you have collective bargaining power. Additionally, in the case of education, A child is not able to give consent. Someone, a teacher, a parent, a family has to give that consent, and they have a duty to the child to make sure that the consent is a proper consent. I'll come back to that in a moment, and I'll answer your question at the same time, because California has experienced this phenomenon earlier than most jurisdictions. Very few jurisdictions in the world, even today, provide you a private legal remedy if a nightmare scenario does happen. And they have happened and they will happen. And in between scenarios that are simply very, very bad for you and your family or your business. What do you do about it? Most jurisdictions in the world do not provide you a remedy at law whatsoever. Some jurisdictions allow you to go to a public agency that, if it wishes to, can pursue a remedy against the alleged wrongdoer, and the agency of the government will collect a fine in money, and they'll keep it. They won't pay you at all. And probably nothing will change the behavior of the wrongdoer. Example, Cambridge Analytica and another company were recently fined in the UK. The maximum fine under UK law for the Cambridge Analytica situation, and the fine was £500,000. No individual victim was paid a penny, and for the people paying, or the companies paying the fine, £500,000 is as much as they earn in about a nanosecond. So it doesn't alter their behavior whatsoever. Coming back to California. California is relevant because by some interesting points of business and legal history, most of the companies that we could name here are in California. And they're fine companies. They're very successful companies. They provide services and other things of value that people worldwide obviously want very much. And they're in California for various reasons. And they are also governed by California law, including the data protection law that I think Arthi has asked me to speak about. In the year 2000, as far as I know, California was the first place in the world to adopt a data breach notification law, meaning that if you are manipulating or using or lawfully holding the data of third parties, a bank, an insurance company, a school, a business, a government, then you have a duty to tell the people whose data you have if there's been a breach in their data security, whether it's your fault or not, and you have a duty to tell them truthfully and to tell them promptly. California was the first place to do that because there had already been incidents, and also it was bad for business. Capitalism does work. If you give consent without reading the form, then the companies would be foolish not to accept the consent. If you withhold consent, they will change their behavior. One can only look at a newspaper any day to see certain social movements that in a remarkably short period of time have had political and social and legal effects simply by virtue of social media. So California adopted this law in 2002. It went into effect in 2003. And I'll come back to that in just a moment. California is one of 50 states. It is one of the 50 states that has had, since more than 100 years, built into the state constitution a procedure for people's referenda. The people of the state of California can and do regularly come together and decide which matters they want to be included on their law books. And they have a referendum, which is called a proposition in California, and if the law is enacted by the people, the politicians cannot revoke it. And just a few weeks ago, another Data Protection Act went into effect in California. It was enacted in California. It's not yet into effect. It will be, when enforced, the most strict data protection law in the world. And it was enacted by the legislature at the last minute because the people of California were about to add it to a popular referendum. The people would have voted for something more restrictive and more empowering to the people. And I think therein lies a lesson. Do not underestimate your power. In fact, social media and the data that you have is a very, very much more powerful lever than the corporate structures or the balance sheets or the alleged stock market values of the companies that want you to think that they are invulnerable. You need them, yes, but they need you even more. Data protection notification also has a fundamental place to play in any national or educational institution's policy regarding the use and ownership of the data that you will produce while pursuing education for humanity. That information belongs to you to be disposed of by knowing consent, not just by signing a form. That is what the companies are after, and they should be after it because capitalism actually does work, including the most important part of capitalism, which is if you don't give people what they want, you go out of business and someone else will take your place.
So I want to ask one more question to Anantha and then open it up to any questions you might have in the audience. On this point of, in your position, you look at and you know and you talk to the ministers of education in different developing countries, right? Even at this conference, you have representatives from different countries who are here. Do you observe political leaders aware of and asking the important, hard-hitting questions around data ownership? Or do you observe more of a sort of disparity where maybe political leaders are eager to get some deals going, eager to get the free Chromebooks or whatnot, and maybe hesitant to raise some of the accountability questions?
I think at this particular moment, the real focus is, it depends on countries as well. And I refrain from using the term developing. It's the criteria that is used to categorize countries is a wrong criteria to sort of say you're developed versus developing. So, but countries who are in a path where the education systems are now starting to get more mature, I think their main focus is actually to get the infrastructure, getting the content. So there's very little attention to the data privacy. But saying that, I think even in some of the more matured countries, that this discussion still hasn't been brought up. And then only recently, now at UNESCO, with the emergence of artificial intelligence that is starting to creep into education, the whole notion of ethics. And so there's a big move now within UNESCO to rally member states. There was a bit of a pushback, but I think the senior management is sort of saying this is important and we need to start addressing this issue. I want to, this is a disruptors panel, so I'll try to disrupt the lawyers a bit. Economists like to do that, especially with the lawyers. If you look at so there isn't a cost-benefit analysis has been done here. So in a sense, there is a cost. There are benefits as well. And I'm looking at education, where if we muscle that, what I call the second degree information, that cannot be used to further learning and I'm looking at the individual child. But again, the potential for abuse is very high. But I think what is necessary is to sort of look at the cost of those potential abuses and you can do a frequency analysis of how often, what's the personal cost, versus the societal benefits that arise. And then it's a societal decision to sort of say, do the cost, do the social, let me use the word social, the net social benefits, positive or negative.
I think one of the challenges with that is imagining what the costs are when there's still so many unknown costs. For example, with theft of medical data, how will that get used? What will be the detriment to people?
Or leave it to the economists. We have many techniques to, we use hedonic pricing, we have techniques to do that, but that's why we don't use market prices for that, we use what we call shadow prices, social prices. We go out and do surveys with people. What is the willingness to pay or willingness to accept? Because we are irrational, the two are not alike. They should be. So I think we need to have a deeper analysis. We need to have a multidisciplinary approach where the economists put in their analysis, the political economy in terms of institutions. That's the one that interests me in terms of who manages that second level information. It's like a commons. And if you don't manage that commons, it gets completely depleted. And in this way, means it gets completely abused and hacked. But I think it's still very early days to go on a very, very strong regulatory approach. And that was purposely put there to tweak Dan.
Perfect. The disruption, perfect. Cost benefit and ethics or utilitarianism is certainly two different categories. And if history has taught us something, ethics and cost benefits may live alongside each other, but in my opinion, ethics has the priority, and law. But I just want to mention one thing in terms of everybody's been talking about these two layers and ownership to data. Let me share some insights into what we say in Europe in terms of ownership to data. Actually, there was a big, almost metaphysical or philosophical debate when the GDPR was discussed. Do you own your data? That was the discussion, the legal discussion. And the consensus is that you actually don't own your data. Not your private and personal data. You may own certain so-called reputational data, which has commercial value to you. But your personal and private data, there is no ownership over that. It's very important from a legal point of view, because if you owned your data, you could alienate that data, which means you could give up that data. And actually, when you pass away, that data would be inherited. You could pledge that data. You could sell that data, and you could never get it back. You could never rectify it, and you couldn't transfer it from one entity to another. Now, if you look at the GDPR, that is actually what you can do. You have the right to rectification of inaccurate data. You have the right to transfer your data from one service provider to another. And you can actually also have data deleted under certain conditions. So the basic philosophy in Europe, which is really the backbone of the GDPR, is that you don't have ownership over personal data. The relationship between you as an individual and the company that collects your data is more of a fiduciary nature. Actually, in the UK, they are looking at the duty of care of data. And once you look at the relationship between the company that collects your data and you as a fiduciary relationship, as a trust relationship, it's much easier to deal with the legal implications. Because if somebody abuses that trust, well, he loses any right to exploit that data. This is very, very important. So that's the first level. You don't own data in Europe. The second level, which you're talking about, is then the aggregate of that data. Now, that is what we would call databases in Europe. And we have a directive dealing with databases which actually protect them. The database as such, or the algorithm that profiles on the basis of data, is subject to intellectual property rights. And you can actually assess ownership over that, but not over the data belonging to each of you in this room personally. This may sound very metaphysical, but it has enormous ethical and legal implications.
So, on that very nuanced description of what's happening in Europe, I have to say, I was hoping we would be able to take questions from the audience, but I've gotten strict orders to wrap up the session. So, what I would, we don't get to throw that out, no. So what I would ask is, when we are wrapping up, if you want to come and speak to any of the panelists to ask the questions that you might have, please do so. Everyone here is very approachable. And thanks for listening to the conversation and continuing it and contributing. Thanks.
Thank you, Audrey.